The 1830s was a time of rapid growth for the country, both economically and geographically. But many people in the United States at that time felt elected officials no longer represented the people, but instead were more concerned with their own political power. General Andrew Jackson, a former U.S. Senator and war hero, was one of the people who worried about the corruption in Washington. And back in the 1800s, the word corruption meant more than taking a bribe or stealing money from the government. In a letter to a friend, he once wrote,
"I weep for the liberty of my country when I see the rights of the people bartered by congressmen for promises of office."
To him, corruption were people who, first and foremost, had been in office for too long. They had been in office so long that it was essentially something that was handed down. It had almost become a kind of hereditary position. Officials who were corrupt oftentimes weren't in their position because of something they had done based on merit. It was based upon birth in a certain sense.
Jackson was nicknamed Old Hickory because of his legendary toughness. When he was 13 years old, he joined a militia during the Revolutionary War and was captured by the British Army. When Jackson refused to shine the boots of a British officer, the officer raised his sword, aiming it at Jackson's head. Jackson lifted his arm to protect himself, and the sword slashed him across his hand and face, leaving permanent scars. Jackson also led U.S. forces during the War of 1812. Sam Houston and Davy Crockett even served under his command. And Jackson had killed 3 men in 3 separate duels. In fact, he still had bullet fragments in his shoulder and chest from those duels.
Andrew Jackson is really one of the more interesting people in American history, in that he's such a very strong personality. Andrew Jackson is one of those people that could walk into a room and dominate. Many of his followers were frontiersmen, but there were other people as well. There were people who had been previously rural people and moved into the cities, and working class people supported Jackson.
Jackson called for reform in Washington to put an end to the political corruption he claimed was common in government. His many supporters organized a campaign, and in 1828, Jackson was elected president.
So when he came to Washington for his inauguration, there was a huge throng of people who came. The entire throng virtually followed him to the White House and then followed him into the White House. And Jackson was pressed up against a wall by this crowd, and he ultimately had to be sort of escorted out of the side there. And the White House itself was just torn to shreds inside. They ultimately only got the crowds inside the White House to go outside by dragging a bunch of tubs of punch out onto the front lawn to get everybody to leave.
When President Jackson took office, there were many issues he needed to deal with. He set out to create policies of reform in order to eliminate the national debt and return to the ideas of limited government. But there was one policy that would turn out to be the most controversial. It was the Indian Removal Act of 1830. And it caused a great deal of anger when Jackson proposed it during his first address to Congress.
Jackson made it very clear that if, in fact, Indians chose not to remove, that was their choice, but that they were going to be subject to state law. And the implications there are really very dark, because either way, you're going to lose your tribal integrity or your land. I mean, either you remove and you lose your ancestral homes, or you stay and you cease to exist as a tribal entity.
He looked at the United States as a frontier nation moving westward. He was committed to making it happen. And in order for it to happen, the Indians had to be out of the way.
Despite the harshness of the Indian Removal Act, President Jackson was determined to move ahead with his policy. He claimed removing the Indians west would be the best thing for them. Like many people during that time, he felt the Indians would never be able to be a part of American society, and their culture could only be preserved by moving them out west.
Jackson was clearly no lover of Indian culture. He made that apparent, and in as much as he was, and I think he was probably pretty much just a man of his own times, he thought the Indian way of life was inferior to the white. On the other hand, I think there's also considerable evidence that Jackson did, however hard it may be for us to understand in this day and age, that Jackson did have some concern for the Indians. that, in fact, if they wanted to maintain what he regarded as an inferior culture, if they wanted to maintain it, that they should be allowed to maintain it, but it had to be done in the West.
The problem with Jackson's plan was that many of the Cherokee did not agree. Many of them did not believe it was in their interest to be uprooted from the places where they were accustomed to live. And many of them were convinced that they were not doing so by their own consent.
The federal government had asked Native American people, Indian people, to make a lot of changes, and the Cherokees particularly had made many of the changes that Jackson and the federal government had already asked them to make.
But he also had other reasons for wanting to remove the Indians. First, he was concerned that the Indians occupied areas that were important for U.S. military defense. And second, Jackson did not like the idea that Indian tribes considered themselves nations within the states. He believed anyone living within the boundaries of a state should have to follow that state's law.
And in Jackson's estimation, talking about Indian sovereignty as though this weren't territory of the United States, properly speaking, was simply false.
Andrew Jackson did not agree with the tribes that they were sovereign nations. He stated to Congress that the Indian tribes are established in the midst of a superior race, and without appreciating the causes of their inferiority or seeking to control those causes, they have to yield to the circumstance, and they must long disappear.
But perhaps one of the biggest reasons for removal was that Indian land was valuable.
The lands on which many of the tribal people were sitting on were very good agricultural lands. And in the period after the War of 1812, after the cotton gin becomes widespread throughout the American South, then the Cotton Kingdom wanted to expand westward in through many of the tribal lands. In addition to that, in 1828, gold is discovered on Cherokee lands in Georgia. Now, much of the land on which the Cherokees were sitting was upland mountain area, which wasn't quite as good farming land. But when gold was discovered, it made it very valuable, and the Georgians were very eager to get the Indian people off that land.
Despite the outrage some people expressed towards the policy, President Jackson insisted that removal was voluntary, but many tribes disagreed.
Tribes did not have to go west. But if they stayed in their old homelands in Georgia, Alabama, Illinois, Indiana, they were subject to the local governments. Consequently, you could remain in Georgia, supposedly, or Alabama, and remain as a Cherokee or as a Creek. But if you did, you had to deal with local settlers who had really little sympathy with you. And the other side of this is when the removal policies came in, and parts of the tribes agreed to go west, then all the federal services that were provided to the tribes would be provided only in the West and not in the old homelands.
Since the Indian tribes had property rights, the U.S. government had to negotiate treaties with the tribes in order to buy their lands. Many tribes, like the Choctaw and Chickasaw Indians in Mississippi, agreed to sell their lands and move to what is now Oklahoma. But the Cherokee Indians in Georgia refused to move. They had taken up farming and established their own state with its own constitution.
The Cherokees had their own language, they had their own printing press, they owned their own plantations, they owned slaves, they ran their own restaurants, they ran their own turnpikes, they published their own books. Basically, we're living certainly on a level with most non-Indians on the frontier.
They had a literacy rate that was virtually 100%. They had a higher literacy rate than the state of Georgia did. They were just about 100% literate in the Cherokee language and probably over 75% literate in the English language.
But Georgia and Andrew Jackson wanted the Cherokees out. So, the state passed a series of laws which allowed it to forcefully take the Cherokees' land and abolish their constitution. As a result, the Cherokees sued the state in the case called Cherokee Nation versus Georgia.
The Cherokee Nation's argument was because they had negotiated directly with the federal government, the same as the British or the French would negotiate with the federal government. They too, the Cherokee Nation, were an independent country. And therefore, they should be treated as an independent country living inside the state of Georgia. In response to this, the Supreme Court said, no, you are not an independent country. You are a domestic dependent nation.
What this meant was that they could internally control their own government, control their own laws with their own people. However, the U.S. Supreme Court did not have jurisdiction to hear their concerns because they were not a truly independent sovereign nation.
So they were a politically separate people. They were a distinct people. But at the same time, they were still subject to the sovereignty of the United States. But they were not subject to state law.
The court was sympathetic to the Cherokees. Chief Justice Marshall had even called the actions of the government disreputable.
Here were people who had done everything, essentially everything, that was supposed to constitute civilization. When people who said that they needed to civilize if they wanted to remain what they had in mind, the Cherokee had done virtually all of it.
But the Supreme Court ruled it did not have jurisdiction and could not hear the Cherokees' case. But Marshall, in an unusual move, hinted that a proper case with proper parties could be heard by the court. This hint gave the Cherokees hope that if another case were brought before the Supreme Court, their voices might be heard. Samuel Worcester was a white Christian missionary who had been given permission by the Cherokees to live on their land. Missionaries like Worcester caused a lot of problems for states like Georgia because they would often advise the Indians of their legal rights.
And the missionaries were pretty much responsible for the incredible literacy rate in the Cherokee Nation. They modified their printing presses to print in the Cherokee language. This is all empowering to the Cherokees.
From the Georgia's perspective, these missionaries were very dangerous because the Georgians were frightened that if these missionaries and the Indians were able to establish a society that was very well entrenched here, that it would be impossible to remove them.
Realizing Worcester and other white missionaries might encourage the Cherokees to resist state law, Georgia passed a law forbidding whites to live on Indian land without a permit from the state. When Worcester refused to leave Cherokee land, he and several other missionaries were arrested and sentenced to 4 years in prison.
It's clear the Cherokees have now a test case, and that's, of course, what these missionaries were seeking, was something to challenge the right of Georgia to assert its law over the Cherokee Nation itself.
Finally, in 1832, Worcester versus Georgia was brought to the Supreme Court. By this time, Chief Justice John Marshall was in his 70s and in poor health. He had undergone surgery without any anesthesia, and during his recovery, his wife had died. Physically, he was no longer the man he once was. But Marshall believed the treatment of the Cherokees was wrong, and with Worcester versus Georgia, the proper case with the proper parties had arrived.
John Marshall may have been old and ill, but he was still a Federalist, and he still looked at people like Andrew Jackson as kind of barbarians who are usurping the Federalist ideal. But in Worcester, he really threw it in the face of the Jackson administration and went much further than he had to go.
Does the state of Georgia have the right to assert its own law over Cherokee territory, over Cherokee land? His answer to that clearly was no. He also essentially rhetorically asked the question, by virtue of the fact that the Cherokee have accepted the protection in prior treaties of the United States government, does that mean they cease to exist as a nation? Meaning that Georgia could assert its authority over them. His answer to that was no. He ordered the 2 missionaries to be released, and he ordered a reversal of the court decision with respect to the application of Georgia state law over the Indian Territory itself. That's what he ordered. That's not ultimately what happened.
An order was sent to the Georgia courts to immediately release Mr. Worcester and Mr. Butler, and the governor of Georgia proclaimed that he would hang them before he would abide by a ruling from the U.S. Supreme Court.
The Supreme Court isn't all that powerful, by itself. It's a group of men, now a group of men and women, who wear black robes and say things. Those pieces of paper that they write and they sign mean something only because others who have the power of the purse and the power of the sword, who have the power to make people do things, ultimately with weapons and jails and police officers, to actually force people to comply with the court order.
The state of Georgia refused to follow through with the court's order. And Andrew Jackson, being a strong states' rights supporter, was not expected to do anything to make the state change its mind. But Jackson also knew the whole situation required caution. He did not want to risk a confrontation with Georgia.
At the very same time, really, that this is going on, South Carolina is threatening to nullify federal law. And Jackson wants to do everything in his power to make sure that South Carolina and Georgia do not join forces in the interest of nullifying a federal law, something that he was concerned might actually cause a civil war.
Eventually, Jackson convinced Georgia's governor to pardon Samuel Worcester and the other missionaries. But this didn't mean the Cherokees would stay in Georgia.
After Worcester versus Georgia, the Cherokee position deteriorated. Pressure was placed on the Cherokees to sign a removal treaty and to remove into the West. The majority of Cherokees did not want to go. The vast majority of Cherokees wanted to remain in Georgia in their traditional homeland. But a minority of Cherokees, a group of people led by Major Ridge, the Boudinot's, some of the other prominent Cherokee families, thought that the handwriting was on the wall and they should probably cut the best deal they could with the federal government and remove to the West. So on their own, they signed a treaty in 1835 called the Treaty of New Echota.
The treaty required the Cherokees to give up all their land east of the Mississippi River, nearly 8 million acres. In exchange, they were to receive $5 million and land out west. Many Cherokees resisted, saying they had never agreed to the treaty. They begged the Senate not to ratify the treaty, but it was too late. The Cherokees were rounded up and held in prison camps. Soon, they were forced to move west without proper supplies. The long journey became known as the Trail of Tears, and it's one of the most tragic events in American history.
The name the Trail of Tears stems from the tremendous loss of Cherokee life on the trail itself. Of about 12,000 who removed, about 4,000 of them died along the way from a variety of things, from exposure, from malnutrition, some from disease. But you're talking about essentially a third of those who were going to remove in the first place perished before they ever got there.
The people who signed the treaty believed they were acting in the tribe's own best interests, but most Cherokees did not. And after the Cherokees arrived in Indian Territory, many of these people who signed the treaty, the Ridge Boudinot Waity Party, as they were known, were assassinated by other Cherokees.
Certainly, they understood that by entering this treaty and by signing it, they had signed their own death warrants because it was a punishable by death offense to cede Cherokee lands. But my mother's contention was that their families insisted that they felt that if they did not sign a treaty, that the next step was that they would not only see removal, but that they would see executions, and that they did not want there to be a bloodbath.
The Worcester case is just one part of what would become known as the Cherokee cases. But it was important because not only did it reject the idea that a state could pass a law concerning a sovereign Indian nation, it allowed the court the opportunity to express its displeasure with the treatment of the American Indian. Unfortunately, the court was ultimately powerless to stop the removal of the Cherokees. Chief Justice John Marshall passed away on July 6, 1835. He had served on the Supreme Court for 34 years, longer than any other Chief Justice before or since. His replacement was Roger Taney, a former Attorney General and Treasury Secretary. And although Taney would preside over the court for almost 30 years, he is forever associated with our next case, considered the most disastrous ruling in the history of the Supreme Court.